guys hear me all right? You guys hear me all right? Okay, good. So today, we have a few people that wanted to come up. I was on last night on John Robinson's, on his space, and a number of people said that they wanted to hear more from me. Said that they didn't get enough of me last night. Don't know why that would be, but they said they wanted to hear some more. So there's some people that are gonna be coming up here in just a moment. They wanted to talk with me, and obviously I'd rather have these discussions openly so that all of you guys can hear about it. You know, it doesn't do me a lot of good to have one-off, 2-hour-long conversations with people when I could just have a 2-hour-long conversation with everybody. I don't have anything to hide, and it's really beneficial, I think, for everybody to hear what I have to say. Especially if it's your first time. I mean, a lot of people are attracted by the things I have to say, so I figured that the best thing to do right now is to let's bring you in. So those that need to join, I don't know your handles, so if you guys would just go ahead and ask to join. You guys will go down to guest. You'll tap on it, ask to become a guest, and we have a couple moderators right now that are moderating. They'll be able to bring you up. If you guys are part of the group that's wanting to that came to talk with me, then just ask. The moderator will make sure that you're part of that group, and we'll get you on. Let me start by saying, guys, that again, for those of you that don't know me, right, my name is Tanawah M, and we are currently engaged in what is going to be the biggest civil rights case in American history, hands down. This is hands down the biggest case. It's nuts how big this got. It got so big beyond even what I would have ever dreamed that this actually was or what it was going to be. The issue at hand, you guys. Yes, we're talking about indictments by a grand jury. Yes, we're talking about prisoners, but the issue at hand is, what is the role of states within our system of government, right? And that's something worthy of talking about, because if we have sovereign states, then what that means is that those states are not subject to the higher government's law. They're not subject to the Constitution of the United States. And I don't think that that's what anybody believes. That's not what I fought for. It's not what the American people believe. That's not what the Constitution was designed. That's not the Union. So the real question is what is the role of our states within our system of government? Because a sovereign state is defined as a state that is complete in itself, not subject to a higher government's laws. So if these states are sovereign, then that means that they're not subject to a higher government's laws, which means that they can create their own legislation, substitute it for the guarantees of the Constitution, and thus enforce laws differently than what we believe, right? Absolutely, they blame both sides, and they call it abstaining, but constitutional law 171, constitutional law subsection 171. You guys go read it. It's a great statute that you guys can rely upon. It's a federal law, which, remember, the Constitution says this Constitution and the laws of the United States shall be the supreme law of the land. The United States, the statute does apply to states. They don't have the right to be able to say, oh, no, that doesn't apply to us, because no, it does. Because the only thing that makes America America is American laws, right? So the American laws all derive from the Constitution. But this whole concept or notion that the states are not subject to the federal laws, well, constitutional law subsection 171 says state courts and federal courts are equally obligated to guard and enforce every right secured by the Constitution. State courts and federal courts are equally obligated, which means that when you walk into one of these state courtrooms and they say, oh, the Constitution doesn't apply to us, that judge just committed the crime of treason. Refer to Hill versus Weeks, United States Supreme Court. Because Title 28 is the judicial code, right? Everybody knows Title 28 is judicial code. Within the judicial code, there's judicial code subsection 455. Subsection 455 is the automatic recusal, right? It's all automatic recusal. 455 says that a judicial officer has a mandatory non-waivable, self-executing duty to recuse himself if he is an officer of either party. Officer of either party. And for the states, these are judicial officers of the state that just so happens to be a party in the cause when it's a criminal matter. Now, sometimes in civil matters, they're not necessarily a party, and we're not going to go into that necessarily, but anytime the state brings an accusation against you through any one of its agents, the state is a party. Now, there's a couple points that I'd like to make here, right? First off, the federal judicial code absolutely applies to federal judges. So when you are an officer of either party, you have an automatic, mandatory, non-waivable, self-executing duty to recuse yourself under 455. There isn't a single federal judge that can say that Title 28, subsection 455 does not apply to them. Not one single federal judge. So my question is, when 455 states that you have an automatic, mandatory, self-executing, non-waivable duty to recuse yourself if you're an officer by the party, why are these federal judges not recusing themselves automatically? Because they're judicial officers of the United States of America. And the United States of America is a party to the cause. These judges must recuse themselves on the federal side because the federal law absolutely applies to them, right? We're talking about states and whether or not states can abstain, whether or not they have nullification, whether or not they can disregard federal statute. On the federal side, in federal courts, absolutely not. Every single one of the cases in federal court are all unconstitutional because that judge is a judicial officer of the United States of America, and the United States of America is a party in the cause. Go read 455. A judge has a mandatory, non-waivable, self-executing duty to recuse himself if he is an officer of either party. Mandatory, right? Meaning that it must be done. Non-waivable, meaning that you can't waive it, right? And they can't request a waiver, right? Self-executing, meaning that you don't have to tell them to recuse themselves. They have an obligation to do so. You don't have to initiate a recusal because they have a self-executing duty to recuse themselves. And if they don't, then they are acting without jurisdiction while having an automatic recusal. And according to the United States Supreme Court, Hill versus Weeks, they're committing the crime of treason and warring against the Constitution. If a judge takes action in a case in which they have a mandatory automatic recusal, they are committing the crime of treason. United States Supreme Court, Hill versus Weeks. That's federal side, okay? Federal side. So who can be a judge in a federal case? Well, anyone that's not an officer of either party, which means that only state judges can be the judge in a federal case, right? You see how this is laying out, right? We have a system of government that's based upon limits of power. In some cases, the state's power is limited. In other cases, the federal government's powers are limited. And in more cases, both governments' powers are limited, but they're all limited in order to preserve the individual liberties of the people. There is no preservation of the individual liberties of the people when the accuser is both party and judge, right? When a body of men brings an accusation, that same body of men cannot also be the judge in the case because that would be a government of unlimited power. Unlimited power. So to what purpose would we create a constitution that preserves the individual liberties of the people when you provide an unlimited, powerful government who can be both accuser, party, and judge, all in the same body of men? So if the United States of America brings an accusation against you, the state judge must be the judge because he's not an officer of the United States of America. He's detached as a separate government entity. That's the way it's supposed to be. However, if the state brings an accusation against you through any one of its agents, then that means that that state judicial officer has an automatic, mandatory, non-waivable, self-executing duty to recuse himself because he is an officer of the petitioner, right? So therefore, no state judge can be a judge when the state is a party Therefore, the only judge that can oversee it is a federal judge. Thus, the federal judicial authority of the union must extend to all cases between a state and the citizens thereof, referred to the Federalist Number 80, written by Alexander Hamilton. Any dispute between a state and the citizens thereof, the federal judicial authority must extend. Right? So whoever was supposed to join, guys, go down to guest, ask to join. We have moderators that are sitting in here. They'll add you in if you're part of the group that was supposed to be there. All right. So again, Federal Judicial Code, United States of America, laws of the United States, they apply to states. States can't pick and choose which parts of federal laws they want to implement or not implement. That was removed when we removed the localist option. There's no localist option that exists anymore here in the United States of America because we have a union. And a union is defined as two or more non-sovereign states with a centralized governing structure. Because a sovereign state is defined as a state not complete in itself, subject to a higher government's laws. So if you are subject to a higher government's laws, you are non-sovereign. You are not sovereign. Because a sovereign state is a state complete in itself, not subject to a higher government's laws. So let me tell you a little bit of history about sovereignty while we're sitting here waiting. All right? I want you guys to understand sovereignty because it's quite interesting how it came to be. So when we started our country, we started a confederacy. Back in 1776, we were a confederacy. And a confederacy is defined as two or more sovereign states with a loose, decentralized governing structure. Okay? All the states were sovereign. They could act, they were not subject to a higher government's laws. They could act autonomously, however they wanted within their jurisdictional borders. Okay? So 1776, we were a confederacy. Sovereign states. Well, we had a bunch of problems. 3 problems in particular that the people going into Constitutional Congress needed to address. The first problem was there was no way to get the states to actually implement the laws that were created by the central government because they were sovereign. So they were able to pick and choose which laws or legislation they wanted to implement between what was created central government. There was no way to get them to actually do it because they were sovereign. Thus, we created the first branch of government, the legislative branch, right? And that legislative branch is equally represented by all of the regional governments, and they come together, they create laws, and then a federal republic is those laws are then federated out. That's what federal means, is federated. So the central government creates the laws and federate them out to each of the regional governments for application administration. Guys, Clause 1, Article 1 of the Constitution of the United States of America says all legislative power is vested in a Congress of the United States. All legislative power is vested in a Congress of the United States consisting of a Senate and House of Representatives. All power to legislate is vested in a Congress of the United States. Because the states were not supposed to make laws anymore. Confederacies make laws at the state level because there's a localist option. In a union, the United States laws, the laws that affect all of the regional governments, that's where the laws are made. Because we have a legislative branch represented by each of the regional governments. And those governments gave up their sovereignty to join the union to subject themselves to the supremacy of the laws of the United States. Now what happens here is that when the central government creates those laws and federates them out to each of the regional governments for application administration, then we have a neutral, unbiased decision maker, being the state, that's a different government that can act as a buffer between the central government and the people, which is the very role that the states were to provide according to Thomas Jefferson in his definition of federalism. Thomas Jefferson said that federalism is not a single state or small factions of states imposing their will upon the rest of the nation, but instead acting in the aggregate and an essential buffer between the central government and the people. Because the judges were not supposed to be attached to the same body of men creating the laws and bringing the accusation. Because if they do, then there's a conflict of interest. That judge cannot be judge if he's part of the same body of men bringing the accusation, creating the laws, profiting off of the enslavement, involuntary servitude of the people that they put behind bars. Okay? So the way it was meant to be was that the United States of America, all legislative power is vested in Congress of the United States. States do not make laws that affect the people. They don't. Because we the people created the Constitution, right? Constitution creates jurisdiction. Jurisdiction granted it. Okay? So Article 3 says, the trial of all crimes, with the exception of impeachment, shall be by jury, and the trial shall occur in the state in which the crime is said to have been committed. So the state was meant to be the judge, because all legislative power is vested in Congress of the United States. So that way, the United States of America makes the laws. They federate them out to each of the regional governments for application administration. That way, all men are equal. All men are equal. No matter where you choose to reside within the jurisdiction of the United States, you are equal because the laws apply equally to you. That's the only way that all men can be equal, is if government and laws treat all men equally. We don't have that today, do we? Because you can go into Oregon and you get a grand jury. You go to Washington, quarter mile away, you don't. You can go down to Alabama and you don't have the right to peaceably assemble and petition the government for redress grievances, but you do in Texas. You have New York that's taking property without just compensation, but yet in Virginia, you're justly compensated. Why do we have this jumbling of these laws together when we were meant to be a union? All right? E pluribus unum. That was the nation's motto. E pluribus unum. Out of many comes one. We have 50 regional governments that are non-sovereign, and those non-sovereign states then are part of a union, and those non-sovereign states gave up their sovereignty to join the union, subject themselves to the laws of the United States, and the Constitution clearly says all legislative power is vested in Congress of the United States. Go ahead and read it, guys. If you don't like what I'm saying, I'm sorry, but read the Constitution. I'm fighting for it. That's all I'm doing. I fight for the Constitution. That's the only thing I fight for, because that's the only thing that's going to preserve and save America from the issues that we're having, from the breakdown, fracturing, and dissolution that we see across this nation today. That is the only thing that's going to save us. So I'm simply telling you the way it's meant to be. If you don't like it, you don't agree with it, I'm sorry. Read the Constitution. You know, if you want to go back to a confederacy because you prefer to have the states have local power and that they create the laws, that's fine. But that's where we were at 243 years ago, before those men went into the Constitutional Convention to address those three questions. Question number one, there was no way to get the states to actually implement the laws created by the central government. Thus, we created a legislative branch. Now, the legislative branch creates all laws, all legislative power vested in it. And when they create a law, it federates out to the regional governments for application administration. Now, if you break a law, the accuser is the United States of America, which is a separate government from the state judge. That state judge can now be neutral and unbiased. He can now act as a decision maker in the situation, because he's not the one that part of the same body of men that created the laws. He's not part of the same body of men that's profiting off the enslavement of the people. He's not part of the same body of laws that's investigating, right? He's a neutral, unbiased decision maker to act as a buffer between the central government and the citizens, just as Thomas Jefferson said. But the problem is that that's how it was meant to be. The United States of America creates the laws, and as a result, the Constitution says that the trial of all crimes, with the exception of impeachment, shall be by jury, and the trial shall occur in a state in which the crime is said to have been committed. Trial was to be done by the state if the United States of America brings laws. But if they don't bring the laws, Article 3 says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. So if a state is a party in the cause because they're bringing an accusation because they decided to create their own laws, then there must be a new judge, because the state can't be the judge. That's why the founders and forefathers and framers said, oh no, Supreme Court is now the judge. Original jurisdiction. In all cases in which a state is a party, the Supreme Court has original jurisdiction. Now, why did they choose the Supreme Court? Well, first off, because that was the only court that existed at that point in time. The establishment of the Constitution only identifies the Supreme Court. That's the only Article 3 court that there is in the country. It's the only one, because that court, its role is to preserve the Union. So when you go to that court, they don't make decisions that's in the best interest of the state. They make decisions that's in the best interest of the preservation of the nation. They knew that it couldn't be like a district court judge, because the district court judge is raised up out of state. He still has state prejudices, interests, bias, and jealousies. He's been practicing law a very specific way because the state taught him to do it. So his whole career's been a lie because he's doing what the state wanted him to do under state laws. Couldn't be them, because there'd still be bias, prejudices, jealousies, and interests. You guys, you go into the central government now. Wait, how you doing? So when you go into the central government now, and you guys bring a case to the district court, you know, the problem that you guys have is you think you're going to win, and you're like, I'm going to win. It's a lock solid case. Constitution says it. The problem is that you're up against a judge who has practiced law his entire life from a state. Do you think that he's going to admit that his entire career has been wrong? Do you think that he's going to be able to lift those blinders and acknowledge the fact that he has been doing it wrong his entire career? It's not going to happen, right? We're talking about the federal Supreme Court. So again, the way it was designed to be was the Union. The states gave up their sovereignty to join the Union, subject themselves to the supremacy of the Constitution of the United States. That's number one. They're no longer sovereign, right? Number two, okay, we got one timed out. Okay, so number two is that all laws were to be created by the central government, by the Congress of the United States. That's what it says. All legislative powers vested in Congress of the United States. That's number two. Okay. Number three, if the state creates laws, then the judge must be the United States of America. And that's upheld by the Federalist number 10, James Madison, where he says that no man is allowed to be judge in his own cause because his interest would no doubt bias his judgment and not improbably corrupt his integrity. With equal, nay, with greater reason, a body of men are unfit to be both judge and party at the same time. Or you can go to Alexander Hamilton in the Federalist number 80, where he said that the federal judicial authority of the Union must extend to all cases between the state and the citizens thereof. If there's a dispute between a state and the citizens of that state, then the federal judicial authority must extend. Alexander Hamilton. He also said that state tribunals cannot be presumed to be neutral and biased when they speak for themselves. No man ought certainly to be a judge in his own cause or in any cause with which he has the least bit bias or interest. Alexander Hamilton said that state tribunals cannot be presumed to be neutral and biased when they speak for themselves. Okay? And now we can also go to John Jay, who was the third author of the Federalist Papers, and his decision and ruling within Martin versus Hunter's Lessee from 1811, where it says, state prejudices, state biases, and state interests might from time to time obstruct the administration of justice by state judges. The Constitution presumes this. Therefore, it is the case and not the court that grants jurisdiction to the United States Supreme Court, because the Constitution says in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. So this whole issue, everything I'm doing, has to do with what is the role of the states within our system of government. If we're a confederacy, then the states can make their laws. They can substitute them for whatever, and that means that the states are more powerful than central government, which means that Supreme Court, you can go home. We don't need you anymore. You have no role. Congressmen, senators, United States, the Capitol building, shut it all down, because you guys don't have any role, because you're not supreme of anything. You will have ceded your power, given them back to the states. And if that's the case, then that's fine. Tell the people of the United States that we live in a confederacy, and then we're going to have another discussion, because Article 1, Section 10 of the United States Constitution says, no state shall form a confederacy. So confederacies are barred against anyway within our constitutional government. So if that's what you want to do, if you want to say you're sovereign, you want to go with that, if that's the argument you want to make it, states, fucking make it, bring it on, because you're still barred from having a confederacy because the Constitution says you can't do that. So the law is on our side regardless of which direction you want to go. And Christina, welcome on here. Go ahead and unmute yourself, please. So you can unmute now, Christine. Looks like you're gonna have to do it if you want to come up, talk. While she's coming up, guys, Kristalina, you're gonna have to unmute, tap on your screen, it'll pop up, little thing there, down at the bottom. Actually, you don't have to tap on the screen because that starts the video feed if you want that. Down at the bottom here is your little mic, down at the bottom, click on your mic. There you go. Yep, perfect.
Yes, sir.
Go ahead.
Oh no, I'm a child advocate, so everything you're telling the people is absolutely correct. So I'm sitting back, listening, and enjoying what you're saying.
Okay. What, do you got any questions for me now that you're up?
Not right now.
Okay. All right. So another thing, guys, is I'm not a big fan of Chief Justice Marshall. You guys know I'm not. I don't like these assholes there. So if you guys want to come up, go ahead and ask to come up. Looks like we got another guest. I'm gonna bring you up, guys. Donnie, hang on a second here. Hang on. So you guys know that I'm not a very big fan of yeah, Captain Quincy. Yeah, we'll bring you up too, brother. Just ask to join. I want to say one thing there, though, guys. So Chief Justice Marshall, he made a statement in the case Marbury versus Madison. And what he said is the power of government is defined and limited, and those limits can never be mistaken or forgotten because the Constitution is written. To what purpose are powers limited, and to what reason are those limits committed to writing? If these limits may at any time be passed by those intended to be restrained. The difference between a government with limited powers and unlimited powers is abolished. If these limits do not confine the person on whom they are imposed, and if acts prohibited and acts allowed are of equal obligation. It is a proposition too plain to be contested that the Constitution controls any acts, statutes, customs, or rulings repugnant to it, or that the judiciary may alter the Constitution by simple ruling made by a group of judges intent upon the advancement of industry and not upon the will of the people. That last sentence I added, by the way. Go ahead, brother.
I got a question. Have you read the UPU?
I read what?
The UPU?
UPU.
The Universal Postal Union?
No, I don't do that. No, because at the end of the day, at the end of the day, anything that's not the Constitution is unconstitutional. So I'm relying upon the Constitution. Like people bring up the UCC and stuff. I'm not going to argue UCC because UCC is not Constitution. So
it was made by other powers by the administration.
Yeah. Now the postal system was certainly codified in the Constitution. It's identified within Article 1, Section 10 or Article 1, Section 9. So, we do have that called out. But nonetheless, the inferior law that would be a product of the Constitution, I'm not going to mess with it because I'm trying to deal with the Constitution. What we want the Constitution back at its foundation. And the way we do that is first, we remove all the bullshit that the executive branch put in place. All their policy, get rid of it. Chevron did that. The second thing is we need to remove all the bullshit that judges built, all their rulings that they called case law. Once we remove that, the Constitution will fall back to the foundation, and now we will be able to rebuild a system consistent with what the people believe in. But the first step is we must put the Constitution back at its foundation.
Because right now they're acting under a RICO. Correct?
They are certainly a RICO right now. Yeah, and that is what we're pursuing. So a RICO is the only offense here in America that can be prosecuted. It's the only offense that can be prosecuted by any private attorney general. So I can step up and fill that role, prosecuting on behalf of people in the United States for the RICO offense. Now there's a couple of points here. One is that
oh my God.
Yeah. Okay. So what do we got? We got Hosea. Someone else has a question? Go ahead.
I was interested in you talking more about Sam's case.
Okay. Awesome. Yeah.
That's what people are asking a lot of questions about. Please bring that up. Thank you.
Yeah, so guys, what we have right now is we have a very, very interesting situation. Because what she's referring to here is Sam Ricks. Sam Ricks is a family issue. Her children were taken from her quite violently by the state of Oklahoma without lawful authority. I'm not going to go into the details of the case, but I'm going to say that just like the rest of us, the state had no authority whatsoever to take those children from her. And Sam was persistent, and she pursued the avenues of reconciliation to restore her children to her and seek a judgment, and she got it. Now, a lot of people are going to say, now you guys can see this judgment. You can go out to the United States District Court of Western Oklahoma, right? And you guys can we mute that real quick here? That's going to, so you can go out to the United States District Court of Western District of Oklahoma. You guys can go out to my page, and from my page, you guys can actually, you can see the case number. Case number is right there. You guys are welcome to go to it. You know, it is on Pacer. You guys can see it. It is a legitimate case. It is filed. It has a case number. It has a judgment. It has a verdict. It was a jury trial, although it was a common law jury. And we're not going to go into the elements of that common law jury quite yet, because there's some secrets that we don't want to quite disclose quite yet. But I'm going to tell you that this judgment is big enough that it will bankrupt the state of Oklahoma. This is big enough that they will have to come to the table and talk to us. And if they don't, then we're going to bring up some more states. And once we start bringing on a couple of these states, I'm going to tell you that if we get 2 or 3 of these states to shut down, because the state of Oklahoma is going to have to shut down. $10 billion that they one single judgment for one single instance, there's hundreds of thousands that we could choose from, right? But $10 billion was what she was awarded by the jury, lawful jury, right? It's signed by the clerk of court. We have the judgment and verdict. There's 2 steps left to do, and we're not going to talk about what those steps are, right? Because those are part of our legal strategy, but you will find out about them in the very, very, very near future. Because once those 2 steps are in place, there is nothing left that they can do to stop this, and we can place liens on government property. We could take, this judgment is in place, all right, and it's 100% valid. And it's requiring 2 things. One is return her property to her children, right, and 2, there's a monetary settlement of $10 billion, right? Now, you guys, she's not going to get that money. Right? We all know that there's going to be, but that's not really what we're so concerned about. She's not concerned about the money, right? She wants her children back, and I hope and I pray that that's what all of you want, because that should be the primary responsibility. Yes, money is a big deal, but guys, the money's worthless anyway, right? It's worthless anyway. But what it does do is it gets us talking about an issue. This will absolutely be all over national news. Sure. This is huge. $10 billion judgment against the state of Oklahoma, one single state, and that's worthy of national news. So, what Samantha did here was amazing, and I applaud her and Ken for the work that they did. Ken, our friend up in Rhode Island, and we're ready to replicate this, but we need to work through the details here. We need to work through the bugs. So it is a judgment that's in place, common law jury. Right? 100% valid. This is very similar to what they did during the Magna Carta, where the lords came together and then they ended up, creating their own law and bringing it to the king and forcing the king to have to sign it out of his dress. I mean, it's pretty much the same thing here, right? I mean, we have the right to be able to have a jury, and that jury can be whatever jury we identify. Jury of peers. She identified the jury of peers. They convened. Voir dire, everything else, and as a result, now they have a judgment that's in place, signed by the United States District Court, and as of right now, the state is not acknowledging that judgment, but that's okay, because we're going to bring enough attention to it that we're going to get it settled. So Gandhi, he said that first they ignore you, right? Then they laugh at you, then they fight you, then you win. They're not laughing anymore, guys. They're not laughing anymore. We provided service this last week on the governor, on the state treasurer, on the state secretary of state, on the attorneys representing all the sheriffs, on the attorneys representing the cities, on the attorneys representing the judges. I mean, we brought the service in the demand letter to all of them, and now the next step is they will be held in contempt if they don't pay her immediately, because they were due to pay within 30 days. Now, there's some ramifications that are very, very interesting in this. And I don't want to go into too much detail, but I know that they're thinking about these same things as much as we're thinking about it, right? And so one thing is that it's not appealable because it was a jury trial. Government can't appeal a jury, right? But at the end of the day, even if they could appeal it, they only have 30 days to do that. That's their own laws. And they waited almost 90 days up until now to submit this demand letter. You know, if they wanted to step up and appeal this or challenge a judgment, they're 60 days past their allotted amount of time. They ignored it, and they waited too long here. So that's issue number one. Issue number two is that how can the corporation come in and defend themselves because the act of deprivation was without lawful authority, and the corporation is not a person, right? She's bringing the person. So the only way that they could do it is the actual individual in their personal capacity would have to come into courtroom and then say, no, these aren't valid. But in doing so, they'd have to acknowledge the judgment. They'd have to acknowledge the case. They'd have to acknowledge so that's why they're ignoring it. Right? They don't want to acknowledge the case, because just like with all of you, right? You know, if we follow and take a play out of their own book and we follow what they do, right? Don't you think that you'd win? So, you know, what is it when you bring an accusation up against them of a criminal act? What do? They ignore you. They just ignore you, right? Why are we not ignoring them? They have no authority to call you in that courtroom. You know it. So, you know, it's well known that with the narcissist, there are certain ways that you defeat them. The first and foremost way is you ignore them. That pisses them off. It makes them so mad because they can't control you. That's all they want. They want to control you. But you don't have to let them do that. So, hey, Wade, how you doing, brother? So where we're at right now is with Samantha is we've got just a little bit more time, a couple more things. Like I said, there's two more things that needs to be done before there's no getting out of this. And once those are done, there's not going to be any news in the country that's not going to be running the story. $10 billion settlement judgment against the state of Oklahoma. Judges, governor, they're all called out, right? And their refusal to acknowledge it is not going to be sufficient when the judgment's on the record. Okay?
Hey, I have a question.
Yeah, Wade.
How did this judgment come about? How did you get the judgment?
So I would have to bring Ken into this, and Ken is yeah. So he was the architect of it, but I know enough about it, but I don't want to go into it. And
Can I say something?
Yeah.
So I was actually with Samantha taking a lot of these systems down because they were chasing her around from Georgia to Mexico and Texas. So Kimberly and I got involved with Samantha, and we helped her, help take down those areas. And the day that she got picked up, we were on the phone with the cops.
Yeah. Yeah, I don't want to go into the details of it because one, I don't know where we're at on other cases, and I know that Ken's working with other groups right now, and like I said, this is enough that we could shut down the first corporation. This could shut down the Oklahoma corporation. This is enough to do that, right? And because this is enough to shut down one corporation, then I know that we're replicating this and trying to get this duplicated, because we're gonna have to fly under the radar. If we don't do this quickly, right, then it may not be as effective. But if we can get 3 or 4 states, in a situation where they're going bankrupt, that Supreme Court of the United States is gonna be begging for me to come back and have this debate. begging for me, right? Because you know, once again, my argument, yes, it includes prisoners, and yes, I'm pushing prisoners, but that's for a very, very specific reason. And but ultimately, this is what is the role of the states within our system of government. Is the Constitution of the United States the supreme law of the land? If it is, then the fundamental rights that are codified in the Constitution, be it enumerated or unenumerated or found to exist, it doesn't matter. Every single fundamental right that's protected by the Constitution can never be infringed with by any state, period, ever, right? Because if they could, then that would mean the state law is more powerful than the central government's laws, and that's not what we live in. That's not the system we live in. So if there's a fundamental right to have a relationship with your child without governmental interference, as found and incorporated in 1984 by the United States Supreme Court, then that means that no state can interfere with your right to have a relationship with your child. That would be interfering with it, and that would be abridging the fundamental right identified by the United States Supreme Court in 1984, Roberts versus United States. But my problem is, you guys, and the reason why I'm going with prisoners, the reason why I'm using indictments is because there's a difference between an enumerated constitutional right and an unenumerated constitutional right. Enumerated means it's written. It's right there for all to see. So freedom of speech, freedom of religion, freedom of press, the right to bear arms, the right to an indictment by grand jury, the right to a speedy trial, the right to not self-incriminate, all of that is enumerated within the Bill of Rights, first 10 amendments. When you're challenging a constitutional right, the ones that are enumerated are guaranteed no matter who you are. This is a decision that came from the United States Supreme Court, 2019, Timbs versus Indiana. That's TIMBS versus Indiana. What the Supreme Court of the United States said there was they said that the privileges and immunities of United States citizens are at a minimum those enumerated within the Bill of Rights, given their legal effect against interference by the states because of their codification in the Constitution's text. So I know you guys don't like the term privilege, but let's get past that for a moment and let's just say that the privileges and immunities of United States citizens are at a minimum what is in the Bill of Rights. Now, I also know you guys don't like the term United States citizen. But remember, I didn't choose a sovereign route. I didn't choose a sovereign route because I want to defeat the system, and the way that I do it is through the citizenship of the 14th Amendment. Because the 14th Amendment states, no state shall create or enforce any laws that shall abridge the privileges and immunities of United States citizens. So if I claim sovereignty, I can't go to the 14th Amendment and use the Privileges and Immunities Clause of the 14th Amendment to say, oh no, I'm entitled to that at a minimum, Supreme Court of the United States. You said so in 2019 that at a minimum, I get what's right there. 6 of the same justices are on that court right now today. 6 of them. We're already at majority from the people that made the decision in 2019 that said, oh yeah, you are given, no matter what is enumerated in the Bill of Rights. What are they going to say on this one? Oh, well, you get everything but that one. That's not going to fly, right? So no state shall create or enforce any law that shall abridge the privileges and immunities of United States citizens. So if the state creates a law and enforces it that violates any of the things within the first 10 amendments, the enumerated rights within the first 10 amendments, then that would be a violation of the 14th Amendment, but I have to claim citizenship in order to do that because it says the privileges and immunities of United States citizens are at a minimum. So you can't go sovereign and still participate in the political process against the states because you are not part of the corporation. If the citizenship is a shareholder, which it is, right? You're a shareholder of the corporation, then under corporate laws, under corporate bylaws, I can walk into that corporation and I can demand a board meeting as a single shareholder, and they must have it. You see, one thing that's happening with a lot of you guys is that you're being sent in a lot of different directions by diversions because government wants you heading in a different direction. They actually want you to go sovereign, right? They want you to go that route because that means you can't walk into the Supreme Court and demand a hearing with Caesar because you're not part of the corporation. If you want to demand a hearing with the court, you must be able to execute. You must be able to walk in and invoke certain rights, because you're not participating in the political process if you are not a citizen. You're not part of the corporation. They want you to go that route. So a lot of things they do is steering us in directions because they're trying to find a way out of this situation here, and we don't want to let them do that to us. So the reason why I'm using the indictment issue is because that's enumerated. Today there are more than 700,000 people currently imprisoned here in America on direct facial constitutional violations because the states did not follow the enumerated duties and responsibilities, procedures, processes codified in the Constitution for the adjudication of crime. Therefore, through the 14th Amendment, no state shall create or enforce any laws that shall abridge the privileges and immunities of United States citizens. We can now challenge as a citizen through the 14th Amendment back to that and say, where is their indictment by grand jury? All right? Because you court said in 2019 in a unanimous decision that at a minimum, we get those as a privilege and immunity. So, but we're doing that and we're using that mechanism because it's not as strong of an argument to argue for the familial unit because that was just incorporated. So what happened was in 1984, the Supreme Court of the United States found to exist the right to intimate association and they incorporated it through the case Roberts versus United States. It's not written in the Constitution. They found that it existed protected by the First Amendment. That's an incorporated, unenumerated constitutional right. If we challenged that, then Timms versus Indiana would not count because they say it must be enumerated. The privileges and immunities of United States citizens are at a minimum those enumerated within the Bill of Rights. So it's not at a minimum if we went that way. The stronger argument is the prisoners, is the indictment because it's enumerated. We don't want to go the other way. But that doesn't mean that we're not arguing it because my argument at the court is, once again, can a state be both accuser and judge in the same cause? The answer is absolutely not. Article 3. Right?
I have a question. Can you hear me?
Yeah.
Okay. So what about a Fourth Amendment, the right against unreasonable searches and seizures? What if, like a public library sent you a trespass letter saying, you can't be on this public property? Would that be let me hit a couple. What one is what is public property? It's the people's property. How can you trespass on your own property? Right. Government doesn't own that property. We do. It's the people's property. So this whole rhetoric of you can trespass on the park is not true. Right? It has no legitimacy because you cannot trespass on your own property, and that property, the state can't own the property, although they believe that they can under personhood and the Santa Clara County case from 1882. But nonetheless, that's what they're doing. They're saying, oh, well, we own that property. The fuck you do. The people, and that's our property. You can't trespass on your own property. So how are you, state, trespassing me? And that goes once again back to this Santa Clara County and the belief that the state and corporations are person, and as a person, now they can bring an accusation against you, person to person. But the good news is that if the state brings an accusation against you as though it's a person, well, that person is one, which means that all parts of that body of men make up one. It's the person of the state, which means that they're made up of a whole bunch of different parts. If the police break the law, then the judge broke the law too because it's one body. Now, that's the first thing. The second thing is that the Fourth Amendment says that no warrant shall be issued but upon probable cause supported by oath or affirmation. What we're seeing with these informations is that the officers are collecting the information from the accuser, right? And they're reducing it to writing in the form of an affidavit, and then they're taking that affidavit and they're bringing it into a judge and saying to the judge, here, this information is truthful, factual, and correct. But the problem is that officer wasn't a witness. They are presenting the information under their oath, but they weren't a witness, right? Because if they were, that would be them accusing, and they can't accuse. That's why they created information, was because they needed to have a different accuser so that the state could be your accuser, right? So if you cannot issue a warrant, but upon probable cause supported by oath or affirmation, who's taking the oath? Because the accuser isn't giving the oath. The officer is, because the officer is presenting the information as truthful, factual, and correct. So anytime that there's an accuser, and that accuser calls up the police and says something happened to him, that accuser had better be swearing under oath, presenting the affidavit from themselves, which is why my affidavits are accurate and correct, because what I'm doing is I'm going out to the victims. I'm going out to the victims of these crimes, and I'm getting them to sign an affidavit. I'm getting them to, I'm preparing it for them, but nonetheless, they're reviewing it, making sure it's all accurate, truthful, and correct, and then they're signing under penalty of perjury under their own oaths, because that's the way it's supposed to be done. I, as a law enforcement officer, am not presenting the information because I can't. I don't know if that information is truthful, but what I can do is I can collect the affidavit, I can collect the accusation from the victim, and I can bring that into a judicial proceeding, knowing that this information is truthful, factual, correct, because that victim swore by oath or affirmation under penalty of perjury that it is correct, and accurate. That's why our affidavits that we're doing and we're bringing forward is the proper procedures, whereas theirs are all violations of the Fourth Amendment. They're all violations. Now that's number two. And the third thing that I would say is that we got to look at the timeline, please. So if the first step is jurisdiction, does the court have jurisdiction? If they do, then they can proceed. They can arbitrate the issue. If they do not, then they have no They have no authority to call anybody in. They have no authority to create an agent. They have no authority to have a judge. No, they have no authority to do anything. Which means that if we're looking for the first point. That's the point I'm trying to make. Is that we want to find the very first point in which a crime was committed by government, when a breach of constitutional obligation occurred. And if the point was jurisdiction, then that means that everything after that jurisdictional error is all void. So if the warrant was issued after jurisdiction, we don't want to talk about it. All we want to talk about is jurisdiction, right? Did the court have jurisdiction? They don't. Oh, well, then nothing else matters. We don't want to talk about anything else because that's all arbitrated issue, right? All we have to do is identify one point, which is why I say we've got to stop defending ourselves. You guys, I had this conversation with someone earlier today, and she was wanting to go into this courtroom. She was wanting to argue with this judge, and because she's right, she's 100%, absolutely she's right. But she's wanting to go in and prove to this judge that she's right and that the judge is wrong. And I'm saying to her, first off, you know she's a criminal. Why are you going to play with the criminal? Why are you going to ask a criminal to stop committing a crime? You know what they are, right? They're not going to because they're a criminal, and a criminal commits crimes. That's what they do. So if you know what it is, why are you going to continue to mess with it? Why are you going to expect anything different? That's number one. Now, number two is that she wanted to go in and she wanted to prove that she was right. But the thing is that they're trying to create something to arbitrate. They're trying to get you to argue with them. And if they don't have jurisdiction, then that's all you got to talk about. You need to go on offense. You need to say, oh no, you committed a crime right here, government, and I'm not going to talk about anything after that because there is no right to self-defense for public officials. If a public official commits a crime in the pursuance of an outcome, they never have the right to justify that criminal act. Never. If a constitutional breach occurs, you talk about that and you don't worry about anything else. They try their best to get you to argue all these other things, and you don't need to. You don't need to, because all of that is defending yourself. They're giving you orders from the court and they're saying, this is what you did, this is what you did, and you want to defend yourself, and I don't blame you. But that's on defense. You go on offense by saying, oh no, you committed a crime. It's right here. I want to talk about your crime that you did before anything that you can do to talk about my crimes or my alleged crimes or anything. None of that matters. You go on offense. All of you need to go on offense because the states did not have the authority to, one, take your child, because that's a fundamental constitutional right protected by the First Amendment, incorporated by the United States Supreme Court in 1984, Roberts versus United States. Therefore, no state can create a law that directs their agents to abridge that fundamental constitutional right without violating the Constitution of the United States and committing the crime of deprivation of rights under color of law. Child cannot be removed because it's a fundamental constitutional right protected by the Constitution of the United States of America, fundamentally under the First Amendment. That's number one. Number two, they don't have the right to arrest you if the state is a party in cause. And therefore, when the state brings an accusation against you through a prosecutor, through law enforcement, through a judge, through a mayor, through CPS, it doesn't matter. When the state brings an accusation against you, that state may not have jurisdiction to oversee the disposition of that dispute because the judge, just like I said in the beginning, Title 28, subsection 455, he has a mandatory, non-waivable, self-executing duty to recuse himself because he's an officer of the party, right? And you may not be an officer by the party without having the automatic mandatory non-waivable self-executing duty to recuse yourself. You may not ever be both accuser and judge in the same cause, And when the state is made up of a body of men, that body of men is one, and that body may not be judged in its own case ever. Can't do it. Therefore, according to Alexander Hamilton, Federalist number 80, the federal judicial authority of the union must extend all cases between a state and the citizens thereof. So remember this, right? And I'm gonna have to get off because this place closes in just a couple minutes, in 7 minutes, actually. I have 7 minutes, guys, okay? So then I'm gonna have to get off because I'm here.
Man.
So one last thing here is that if you were to go out and read, the duties and responsibility of a prosecuting attorney, written by the Bar Association, okay? Prosecuting attorney, duties and responsibility, prosecuting attorney. If you scroll down to item number 4, it says, the prosecuting attorney shall prosecute all cases, criminal and civil, in which the state has become a party. Let me say that one more time. The prosecuting attorney shall prosecute all cases, criminal and civil, in which the state has become a party. So by their own words, if there is a prosecuting attorney on that case, the state has become a party in the cause, civil or criminal, it doesn't matter. State is a party. And the Constitution says, Article 3, Section 2, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. Right? So criminal's easy. Prosecutor's standing right there. You can see him right there. However, it's not as clear with civil matters, such as a CPS matter, family court, right? So it's clear because there's not a prosecutor in there, right? That CPS agent is enforcing the laws of the state. They're enforcing the law because otherwise they wouldn't have the authority to be able to take your child under color of law. Therefore, that CPS agent is working for the executive branch because the executive branch is there to enforce the laws of the state, which means that CPS officer is operating under the authority of the prosecuting attorney, who is the highest law enforcement officer of your county. The prosecutor is absolutely a part of that case because that CPS agent is operating under the authority of the highest law enforcement officer of your county, the prosecuting attorney. Therefore, in all cases, the duties and responsibilities of prosecuting attorney shall prosecute all cases, criminal, civil, in which the state has become a party. CPS is absolutely an agent of the state. They're enforcing laws of the state. They are taking action under color of law of the state. They're operating under the authority of the governor, and the governor is in control of all law enforcement. That's what his role is enforcement. And as a result, that CPS agent is operating under the authority and direction of the prosecuting attorney of that county. Therefore, state has become a party. And what they produce is unconstitutional. Because in all cases which a state shall be party, even if it doesn't say state of whatever versus you, it's an agent of the state that brought the accusation against you. It is absolutely a state.
Can I ask a question?
Yeah, go ahead. Yeah.
May I ask?
Go ahead.
I was on Sam's jury, and I'm going to be on others, and I'm wondering, will you be handling those cases as well? Is that what we're working on, bringing them all together?
Yeah, so this is what God is preparing me to do, all right? I have a degree in law enforcement, you guys. I have a master's degree in substantive law. That's law enforcement. I was always meant to be in federal law enforcement. I lost my way in the early part of my life, and I decided to go after money. I made a lot of money. I became a very selfish person, but God's called me back to my first love. This is what I was meant to do. I was meant to enforce the laws of the United States. God's called me back to my first love, and I'm here to do that. I have a degree in law enforcement. I'm going to be the one that is going to be acting as the private attorney general on behalf of people in the United States to start prosecuting these people that refuse to step up and fulfill their obligations. And I know that it seems crazy right now to think that, but here's the problem. I have served 42 state attorney generals with actual crimes that are being committed by their agents. They have chosen to do nothing about it. Therefore, they are all in opposition with the people. They are all opposing party to the people of the United States right now, because they're all refusing to recognize and enforce the body laws, govern the nation, and the will of the people. Therefore, none of the attorney generals of the states can represent you guys. There must be someone else now that steps in. And because I personally provided the service for the case against them, I'm the person that will be stepping into that role as private attorney general, and I will be handling, and I'll be presenting this in a fair, neutral, unbiased manner to the grand juries that are being impaneled across the country. These citizen-led grand juries, and I'll be providing that role. That's what God is preparing me to do, 100%.
Thank you.
Can I ask a question?
Yeah, go for it.
Hey, I'm having trouble with my grandbaby right now. She actually told us she was getting touched on her head. And we told the cops, they won't even question him about it. And we did a deposition the other day. Come to find out, after the deposition, the attorney he got was bragging that he represents the sheriff's office that's supposed to be looking into it, and they won't. The sheriff's office actually told me and my wife to come back home and put a timeline back together. And just right, not long ago, you talked about timelines. We come, put it together, he wouldn't even see us after that. And we found out from the attorney himself, and I prayed God would anoint everybody's tongue where no lies can come out. Let the light of his word shine. And he told on himself, is this legal?
It's not. So there's something that's called prosecutorial discretion. And you guys, prosecutorial discretion is bullshit. It's not valid. It can't be valid. And the reason why is because if prosecutorial discretion were valid, then that would mean that a prosecutor can pick and choose who the laws apply to and who they don't apply to. Right? Prosecutor can't say, I'm not going to prosecute. That's not his role. His role is to present evidence in the fairest manner on behalf of the people who have been offended in order to preserve the laws. This is what I do. Attorneys, they don't do this because they aren't trained and qualified in law enforcement. They're not. This isn't what they do. I work on behalf of the truth, right? I want to ascertain the truth. That means that if someone comes to me with allegations of a crime, I don't get to pick and choose whether or not that law is going to apply to that little child or not. I don't get to pick it based upon the strength of my case. No, my obligation is to present it to the grand jury and to let the people decide. This is the accusation. This is what happened. This is the evidence that I have, and let the people decide. It's not the role of the prosecutor to pick and choose, what case they're going to prosecute or not prosecute, because what happens then, and we see this with a lot of women, unfortunately, a lot of adult women right now, because a lot of them were assaulted sexually or molested as a child, and then the state came and said, oh no, we're not going to prosecute for that. I'm sorry, we're not going to do that. And now what that told them was that the laws of sexual assault doesn't apply to them. That judge, that prosecutor just said, oh no, we're not going to do that, because it's not a strong case, or whatever the circumstance is, it doesn't matter. But what they did was they just said that law doesn't apply to you. And public officials can never decide who the law applies to and who doesn't, because we live in a system of government known as egalitarianism, where the laws, in order for them to be legitimate, they must apply equally to all persons. And if they don't, then that's an illegitimate law. Refer to John Locke, Jacques Rousseau, Thomas Jefferson, any one of the founding fathers or philosophers of our system of government. Every one of them would say that if a law does not apply equally to every person, then it is an illegitimate law. What happened to your grandchild was an illegitimate situation, because now we have a law that is not applying equally to all persons within our society, because a person in a position of authority decided that they're not going to protect your grandchild for whatever reason. It doesn't matter. It's not their role to decide, because that's known as oppression or tyranny. Oppression is the creation of laws that apply unequally amongst like members of society. And the second is tyranny, which is the unequal application of those laws by a person in position of authority. So that was a tyrant that created an oppressive law because they just said that your grandchild is not protected by the laws of sexual assault. And that's not okay. It's not okay. Your grandchild absolutely has the right to be protected by the laws in the same way as any other child or adult or person within our society. And it's the role of law enforcement to make sure that they don't misapply the laws or determine the outcome of the dispute, because that's not his role. His role is to present the truth and let the people decide what is or is not the truth. Right? Present the evidence It's up to people. That's why I tell all of you guys, I say to you, I'll be done with a second here. That's why I say that it's not my role to judge. That's up to you guys. All that I can do is detach from the outcome. And if the people of the United States decide that these public officials are traitors, I support whatever the people decide. If the evidence isn't there and the people don't believe it, that's the best I can do. I have the evidence. I want to present that evidence. I want the people of the United States to make this decision. It's up to them. But it's not up to me to decide the outcome, because this is a decision that they have to make, because that's the role of our system of government within the judicial philosophy, within the legal philosophy that we have. We don't have the proper expertise sitting in the position of law enforcement in that courtroom because that prosecutor has the wrong degree, the wrong education. They need to have not a degree that makes a person into a criminal. They need to have a degree that determines truth, because that's the role of the prosecutor within our system of government. So I'm sorry that happened to you, brother. But what did happen to your grandchild is absolutely wrong. And all I can do is pray that this message gets out quicker than it is, so that we can start to resolve these issues that we're experiencing across the country with people that don't understand their role, don't understand our legal philosophy, and certainly don't understand their obligations codified by law and delegated by the people of the United States. So I have to get out of here, guys. I only had until 6:30. If you guys want, I might be able to try to do another live as soon as I get back, but I got to find another place to be there. So, guys, please continue to like, follow, share. Thank you guys for coming up. I love today. It was great. I know I talked a lot, but I would like to do more with you guys. I know you guys got a lot of questions, and I'm very, very sorry that I haven't been there, for you guys to answer these questions. But this is the biggest case in American history, and it takes a lot out of me, guys. It takes a lot out of me. And so you guys got to understand that I only have so much time, and I appreciate everything you guys do for us. I appreciate everything you guys have done. I love you guys so much, and I appreciate everything. Please continue to like, follow, share. Please donate if you can. We are on the ropes, but I'm always on the ropes. What's new? You guys have been keeping me afloat, and I have never in the last 2 years ever had to sleep on a park bench. I've never had to go without food. You guys have been a huge blessing for me, and you guys have made sure that I've had the things I need, because I know that you guys appreciate the things I'm doing. So thank you guys so much. God bless. And I'll try to come back on a little bit later, but right now I have to get out of here. Thank you guys so much. God bless. Have a great rest of your night, okay? Thank you. Thank you, YouTube. Thank you guys so much. God bless everybody. Thank you so much.